ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಹಾಗೂ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ ಲಾ ಅಕಾಡೆಮಿ ಇವರು ನಡೆಸಿಕೊಡುತ್ತಿರುವ ಬೆಳಕು ಮಾಲಿಕೆಗೆ ತಮ್ಮೆಲ್ಲರಿಗೂ ಸುಸ್ವಾಗತವನ್ನ ಕೋರ್ತಿದ್ದೇನೆ. ಈ ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮದ 3ನೇ ದಿನವಾದ ಇಂದು ನಾವು ಶ್ರೀ HK ವಾಸುದೇವ ರೆಡ್ಡಿ, ಬ್ಯಾರಿಸ್ಟರ್ ಅಂಡ್ ಸೀನಿಯರ್ ಲಾಯರ್ ಆಫ್ ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಇವರ ಬಗ್ಗೆ ಉಪನ್ಯಾಸವನ್ನ ನೀಡಲಿಕ್ಕೋಸ್ಕರ ಹಿರಿಯ ವಕೀಲರಾದ ಶ್ರೀ SP ಶಂಕರ್ ಅವರು ಈಗಾಗಲೇ ಆಗಮಿಸಿದ್ದಾರೆ. ಮತ್ತು ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಆಗಮಿಸಿರುವ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ನಿವೃತ್ತ ನ್ಯಾಯಾಧೀಶರಾದ ಶ್ರೀ ಕೃಷ್ಣ ಭಟ್ ಅವರಿಗೂ ಕೂಡ ನಾನು ಸುಸ್ವಾಗತವನ್ನ ಕೋರ್ತಾ ಇದ್ದೇನೆ. ಶ್ರೀ HK ವಾಸುದೇವ ರೆಡ್ಡಿ ಅವರ ಬಗ್ಗೆ ಮತ್ತು ಇದರ ಬಗ್ಗೆ ಒಂದು ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮವನ್ನು ಕೂಡ ಇವತ್ತು ಆಯೋಜಿಸಲಾಗಿದೆ. ಇದರ ಬಗ್ಗೆ ಮಾತಾಡ್ಲಿಕ್ಕೋಸ್ಕರ ಶ್ರೀ SP ಶಂಕರ್ ಅವರನ್ನ ನಾನು ಕೋರ್ತಾ ಇದ್ದೇನೆ. ನಮಸ್ಕಾರ ಸರ್, ಬನ್ನಿ ಸರ್.
ಎಲ್ರಿಗೂ ನಮಸ್ಕಾರ. ವಾಸುದೇವ್ ರೆಡ್ಡಿ ಅವ್ರ ಬಗ್ಗೆ ಮಾತಾಡೋದಕ್ಕೆ ಸಂತೋಷ ಆಗುತ್ತೆ. ನನ್ನ ಅನಿಸಿಕೆಗೆ ವಾಸುದೇವ್ ರೆಡ್ಡಿ ಅವರು ವಾಸ್ ನಾಟ್ ಅನ್ ಇಂಡಿವಿಜುವಲ್ ಬಟ್ ವಾಸ್ ಅನ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್. ಮಿಸ್ಟರ್ ವಾಸುದೇವ್ ರೆಡ್ಡಿ came from a rural background. He was born at Haikal, Chitradurga. ಅಲ್ಲಿ ಚಿತ್ರದುರ್ಗಕ್ಕೂ ಮತ್ತು ಹಾಯ್ಕಲ್ಗೂ ಕೇವಲ 4 or 5 ಕಿಲೋಮೀಟರ್ಸ್ ಅಷ್ಟೇ. ನ್ಯಾಷನಲ್ ಹೈವೇನಲ್ಲಿ ಬೆಂಗಳೂರಿಂದ ಚಿತ್ರದುರ್ಗ ಹೋಗ್ಬೇಕಾದ್ರೆ 3-4 ಕಿಲೋಮೀಟರ್ಸ್ ಮುಂಚೆ ಬಲಗಡೆಗೆ ಒಂದು ಹಳ್ಳಿ ಇದೆ, ಅದೇ ಹಾಯ್ಕಲ್. ಹಾಯ್ಕಲ್ನಲ್ಲಿ ಹುಟ್ಟಿ ಬೆಳೆದು ಬ್ಯಾರಿಸ್ಟರ್ ಆಗಿ ನಮ್ಮ ಕರ್ನಾಟಕದಲ್ಲಿ ಒಳ್ಳೆ ವಕೀಲ ವೃತ್ತಿ ನಡೆಸಿ ಅವ್ರ ಹೆಸರು ಪಡೆದ್ರು ಮತ್ತು ಒಳ್ಳೆ ಇಂಪ್ರೆಷನ್ ಬಿಟ್ಟಿದ್ದಾರೆ. ವಾಸುದೇವ್ ರೆಡ್ಡಿ, ನಾನು ಓಪನಿಂಗ್ ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳಿದೆ, ಹಿ ವಾಸ್ ಅನ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ನಾಟ್ ಅನ್ ಇಂಡಿವಿಜುವಲ್ ಅಂತ. ಅವರು ಅಥವಾ ಅವರ ಆಶ್ರಯದಲ್ಲಿ ಬೆಳೆದಂತ ಬೇಕಾಷ್ಟು ವ್ಯಕ್ತಿಗಳಿದ್ದಾರೆ. ನಾನು ಒಬ್ಬ. ನನ್ನನ್ನ ಈ ಲಾಯರ್ ಆಗ್ಬೇಕಾದ್ರೆ ನಾನು ಆಫ್ಟರ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಐ ಅಪ್ರೋಚ್ ES Venkatramaya of revered memory. He happened to come from same district, and the distance between my village and his village of 17 kilometers. When I mentioned that I would like to join his office as an intern, he expressed pleasure and said, yes, come from tomorrow only ಅಂತ ಹೇಳಿದ್ರು. ನಾನು ಹೋಗ್ಬೇಕಾಯ್ತು. Then ನನಗೆ the coldest reception I had was in the Balepet office of ES Venkatramaya. ಜಾಗ ಚಿಕ್ಕದು, ತುಂಬಾ ಜನ, ಅಂಡ್ ಕೂತ್ಕೊಳ್ಳೋಕೆ ಜಾಗ ಇಲ್ಲ. ಹೋದ್ರೆ nobody gave a smile, nobody welcomed me, and I was feeling frustrated. ವಾಸುದೇವ್ ರೆಡ್ಡಿ ಅವರು ಬಂದ್ರು, ಹಲೋ ಬಾಯ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನನಗೆ 1-2 ಉತ್ತೇಜನ ವರ್ಕ್ ಕೊಟ್ಬಿಟ್ಟು ಸ್ಟಾರ್ಟ್ ವರ್ಕಿಂಗ್ ಫ್ರಮ್ ಟುಡೇ ಅಲೋನ್. That was the greatest encouragement I received from Barrister Vasudev Reddy. I still remember, and my gratitude remains forever. ವಾಸುದೇವ್ ರೆಡ್ಡಿ ಅವ್ರಿಗೆ ಒಂದು ರೀತಿಯಲ್ಲಿ ಹೇಳೋದಾದ್ರೆ ಅವ್ರಿಗೆ ಕೊಡಕ್ ಬರ್ತಾ ಇತ್ತು, ಇಸ್ಕೊಳಕ್ ಬರ್ತಾ ಇರ್ಲಿಲ್ಲ. ಯಾರು ಏನೇ ಕೇಳಿದ್ರು ಸಹ ನೋ ಅಂತ ಹೇಳ್ತಾ ಇರಲಿಲ್ಲ, ಕೊಡ್ತಾ ಇದ್ರು. ಹಾಗೆ ನಮಗಳಿಗೆ ವಿದ್ಯಾದಾನ ಮಾಡಿದ್ರು. ಹಲವಾರು ಜನಕ್ಕೆ ಬೇಕಾಷ್ಟು ಆಶ್ರಯ ಕೊಟ್ಟರು. ವಾಸುದೇವ್ ರೆಡ್ಡಿಯವರು ಅವ್ರಿಗೆ ದೊಡ್ಡ ಮನೆತನದಲ್ಲಿ ಬಂದವರು. ಮುಲ್ಕಾ ಗೋವಿಂದ ರೆಡ್ಡಿ ಅವರ ಫ್ಯಾಮಿಲಿಗೆ ನೇರ ಸಂಬಂಧದವರು. ಅವ್ರಿಗೆ ವ್ಯಕ್ತಿತ್ವ ಇತ್ತು, ಧೀಮಂತಿಕೆ ಇತ್ತು, ಜ್ಞಾನ ಇತ್ತು, ಸುಜ್ಞಾನವಿತ್ತು. ಎಲ್ಲದಕ್ಕಿಂತ ಮಿಗಿಲಾಗಿ ಧಾರಾಳ ಮನಸ್ಸಿತ್ತು. ಅವರ ಹತ್ರ ಇಲ್ಲ ಅನ್ನಿಸ್ಕೊಂಡು ಜನ ಇರಲಿಲ್ಲ. ಹಾಗಾಗಿ ಈ ಪ್ರೊಫೆಷನಲ್ ನಲ್ಲಿ ಅವರು ಎಷ್ಟು ಜನರನ್ನ ಏಳಿಗೆ ತಂದಿದ್ದಾರೆ ಅಂದ್ರೆ ಲೆಕ್ಕ ಇಲ್ಲ. ಹಿಸ್ ಸ್ಟೈಲ್ ಆಫ್ ವರ್ಕಿಂಗ್ ವಾಸ್ ಯುನೀಕ್. He wanted pleadings to be brief. He wanted submissions to be brief. The other person whom I had seen in the bar who was brief in his submissions, had used to make notes while making submissions in the court, was Sri Etirajulu Naidu. Whether it is application for some interim relief, whether it's the main matter, or it was a long-winded submission, he used to come prepared with notes, and he never swayed away from the notes. And the next person was Sri Vasudev Reddy. ವಾಸುದೇವ್ ರೆಡ್ಡಿ ಅವರಿಗೆ ಹಲವಾರು ಹೆಸರುಗಳು ಬಾರ್ನಲ್ಲಿ ರೂಢಿ ಇತ್ತು. ವಾಸಣ್ಣ, ವಾಸು, ರೆಡ್ಡಿ, ಬ್ಯಾರಿಸ್ಟರ್, ಹೀಗೆ ಹಲವಾರು ನೇಮಗಳು. ಎಲ್ಲದಕ್ಕಿಂತ ಹೆಚ್ಚಾಗಿ ಅವ್ರನ್ನ ವಾಸಣ್ಣ ಅಂತ ಕರೆಯೋರು ಜನ ಜಾಸ್ತಿ. ವಾಸಣ್ಣ ಅಂತ ಕರೆಯೋರೆಲ್ಲ ಒಂದು ಕ್ಯಾಟಗರಿಯವರು. ಅವ್ರ ಹತ್ರ ಏನಾದರೂ ಸಹ ಅಪೇಕ್ಷೆ ಪಟ್ಟು ಬಂದು ಅವ್ರ ಹತ್ರ ಆ ಅಪೇಕ್ಷೆನ ಈಡೇರಿಸ್ಕೊಂಡು ಅವ್ರಿಗೆ ಏನ್ ಬೇಕಾದ್ರೂ ದಕ್ಕಿಸ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ದವರು ವಾಸಣ್ಣ ಅಂತ ಕರಿತಾ ಇದ್ರು. ಬ್ಯಾರಿಸ್ಟರ್ ಅಂತ ಕರಿತಾ ಇದ್ದವರು ಪ್ರೊಫೆಷನ್ ಒಳಗೆ ಸ್ವಲ್ಪ ಹೈಯರ್ ಎಚಲಾನ್ಸ್ ಅಲ್ಲಿ ಇದ್ದಂತಹ ವ್ಯಕ್ತಿಗಳು ಅವ್ರನ್ನ ಬ್ಯಾರಿಸ್ಟರ್ ಅಂತ ಕರೆದು ಅವ್ರಿಗೆ ಒಂದು ಸಹಾಯ ತಗೊಳ್ಳೋರು. ದೆನ್ ಮಿಸ್ಟರ್ ರೆಡ್ಡಿ ಅಂತ ಕರೆಯೋರು, ನಮ್ಮ ES ವೆಂಕಟರಾಮಯ್ಯವ್ರನ್ನ ಮಿಸ್ಟರ್ ರೆಡ್ಡಿ ಅಂತ ಕರಿತಾ ಇದ್ರು. ಆ ಸಲಿಗೆನೂ ಇಲ್ಲ, ಸಲಿಗೆ ಇಲ್ಲ ಅಂತಲೂ ಇಲ್ಲ, ಆ ರೀತಿ ಒಂದು ನಡವಳಿಕೆ ಇಟ್ಕೋತಾ ಇದ್ರು. ಅದು ಕೆಲವು ಜನ ಕ್ಯಾಟಗರಿಗಳು. ಎಲ್ಲರೂ ಅಣ್ಣ ಅಣ್ಣ ಅಂತ ಹೇಳೋದೊಂದು ಗೊತ್ತಿತ್ತು. ಅದಿದು ಈ ಒಂದು ಅಂಶ ತಮ್ಮ ಗಮನಕ್ಕೆ ತರಬೇಕು. ನಮಗೆ ಬಾರ್ನಲ್ಲಿ ವಿ ಹ್ಯಾವ್ a larger percentage of Reddy advocates, and every alternative advocate in the trial court is Mr. Reddy, and one in four advocates in High Court are is Mr. Reddy. They are all from Kolar district. Saram Visheshwarnavaru, gold mine iddanta jaga, and they have stopped digging gold in Kolar. Now they have started digging gold in Bangalore. ಆ ರೆಡ್ಡಿ ಅವರಲ್ಲ ನಮ್ಮ ವಾಸುದೇವ ರೆಡ್ಡಿ ಅವರು. ಇವರು ಚಿತ್ರದುರ್ಗದ ಮಹಾರಾಜರು. ಇವ್ರಿಗೆ ಶ್ರೀಮಂತಿಕೆ ಇತ್ತು, ದೆನ್ ಔದಾರ್ಯ ಇತ್ತು, ಇನ್ನೊಬ್ಬರನ್ನ ಮುದ್ದೆ ತರಬೇಕು ಅಂತ ಒಂದು ಆಸೆ ಇತ್ತು. ಎಲ್ಲದಕ್ಕಿಂತ ಹಿರಿದಾಗಿ ನ್ಯಾಯ ದೊರಕಿಸೋದಕ್ಕೆ ನಂಬರ್ 1 ಆಗಿದ್ದು. ಇನ್ ಕೋರ್ಸ್ ಆಫ್ ಟೈಮ್, ವೆನ್ ಶ್ರೀ ವೆಂಕಟರಾಮಯ್ಯ ಬಿಕೇಮ್ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್, he was given the liberty to choose his own team of advocates to represent the interest of the government. Mr. Vasudeva Reddy, as rightly expected from all of us, was the first one to be included in that list of or the panel of government advocates to deliver goods on behalf of the government. Mr. Venkatramaya, as he then was, namely Advocate General, he chose briefs in the sense that extraordinarily important matters ಅಥವಾ where the judges insisted on his presence ಹೋಗೋರು. ಬಾಕಿದೆಲ್ಲ ವಾಸುದೇವ ರೆಡ್ಡಿ ಅವರು, ಕಾಳೇಗೌಡ, ದೊಡ್ಡ ಕಾಳೇಗೌಡ, ಮತ್ತೆ ಶಾಂತರಾಜು ಇವರಿಗೆಲ್ಲ ನಡೆಸ್ತಾ ಇದ್ರು. ಅದರೊಳಗೆ ವಾಸುದೇವ ರೆಡ್ಡಿ ಕಾಂಟ್ರಿಬ್ಯೂಷನ್ ಇಸ್ ಎಕ್ಸ್ಟ್ರೀಮ್ಲಿ ಗುಡ್. Local bodies was his favorite subject, and wherever the petition used to be present and he failed to deliver across the merits of the case, he used to stand up and say, I have the records with me. If you permit, I'll place it before you. And this is the portion. And he used to correct factual errors made by the learned advocates for the petitioners. And he used to tell, yes, there is a mistake. The party is not heard, or such an order is passed without consideration of the available records, or that the order is inconsistent with the records. He used to assist the court, and many a time, so the Vasudeva Reddy ನೀವೇ ಹೇಳ್ಬಿಡಿ, petitioner ಇಲ್ಲದೆ ಇರಲ್ಲ, you are fair to the records and fair to the court, ನೀವೇ ಹೇಳಿ ಅಂತ. This is the merit he had earned at the hands of the judges, and he commanded so much of respect both from the bar and the judges. ವಾಸುದೇವ ರೆಡ್ಡಿ ಅವರಿಗೆ ಒಂದು ಕಳಕಳಿ ಇತ್ತು. ಯಾರಿಗಾದ್ರೂ ಅನ್ಯಾಯ ಆಗ್ಬಿಟ್ರೆ ಅದನ್ನ ಖಾಲಿ ಮಾಡ್ತಿ, ಅನ್ಯಾಯ ತೆಗೆದು ನ್ಯಾಯ ದೊರಕಂತ ನಿದ್ದೆ ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತ ವ್ಯಕ್ತಿ. ಒಂದ್ಸಾರಿ ಅವ್ರಿಗೆ ತುಕೋಲ್ ಸಾಹೇಬರು, ವೈ ಆರ್ ಯು ಅಸಿಸ್ಟಿಂಗ್ ದಿ ಅಡ್ವೊಕೇಟ್ಸ್ ಫಾರ್ ದಿ petitioners, ದೇ ಆರ್ ನಾಟ್ ಹಿಯರ್ ಅಂತ ಹೇಳಿದ್ರು. ಐ ಆಮ್ ನಾಟ್ ಅಸಿಸ್ಟಿಂಗ್ ದಿ ಅಡ್ವೊಕೇಟ್ಸ್ ಫಾರ್ ದಿ petitioners ಆರ್ ಅಸಿಸ್ಟಿಂಗ್ ದಿ ಕೋರ್ಟ್. ಐ ಆಮ್ ಓನ್ಲಿ ಟೆಲಿಂಗ್ ದಿ ಟ್ರೂತ್. ದಿ ರೆಕಾರ್ಡ್ಸ್ ಆರ್ ಲೈಕ್ ದಿಸ್. ಇಟ್ ಇಸ್ ಫಾರ್ ದಿ ಕೋರ್ಟ್ ಟು ಸೇ ದಿಸ್. Certiorari proceedings are calling for the records, seeing the correctness of the stand taken by the government, or the policy decision taken, or the decision taken on the facts of the case. Certiorari means get the records and correct it. That's the jurisdiction, and submitting to the jurisdiction of the court. That was a statement of a real barrister. That was Mr. Vasudeva Reddy. ವಾಸುದೇವ ರೆಡ್ಡಿ ಅವರಿಗೆ ಒಂದು ಹಠ ಇತ್ತು. ಈ ಹಠ ಏನು ಅಂತ ಹೇಳಿದ್ರೆ, ಯಾರಿಗೆ ಅನ್ಯಾಯ ಆಗಿದ್ದೀನೋ ಅದು ರಿಡ್ರೆಸ್ ಮಾಡೋದು ಅವ್ರ ಕರ್ತವ್ಯ ಅಂತ ತಿಳ್ಕೊಂಡಿದ್ರು. ನಂತರ he used to allow the youngsters to come up in life. I am one of the examples. But for Mr. Vasudeva Reddy, the barrister, I would not have been what I am today. ನಾನು ವಾಸುದೇವ ರೆಡ್ಡಿ ಅವರು ಅಕಾಲ ಮೃತ್ಯು ಆಯಿತು. ಅವ್ರು ಹೋದಾಗ ಒಂದು ಸಭೆ ನಡೆಸಿದ್ರು. ಆ ಸಭೆಯಲ್ಲಿ ಎಲ್ಲರೂ ಭಾಷಣಗಳೆಲ್ಲ ಆದ್ಮೇಲೆ, ಶಂಕರ್ ನೀನು ಮಾತಾಡು ಅಂತ ಹೇಳಿದ್ರು. ನಾನು ಮಾತಾಡಿದೆ ಕೇವಲ 90 seconds ಆರ್ 120 seconds. ನಾನು ಅವರ ಮಾತಿನಲ್ಲಿ ಪ್ರಾರಂಭದಲ್ಲಿ ನಾನು ಹೇಳಿದೆ, ವಾಸುದೇವ ರೆಡ್ಡಿ ಅವರು ವ್ಯಕ್ತಿಯಲ್ಲ, ಒಂದು ಸಂಸ್ಥೆ. ಅವರಿಗೆ ಗೊತ್ತಿಲ್ಲದೆ ಇರ್ತಕ್ಕಂಥ ವಿಷಯ ಇರಲಿಲ್ಲ. ಆ ಗೊತ್ತಿದ್ದು ಏನೋ ತೊಂದರೆ ಆಗುತ್ತೆ ಅಂತ ಹಿ ಯೂಸ್ ಟು ಅವಾಯ್ಡ್ ದಟ್ ಇಶ್ಯೂ. ಯಾಕೆಂತಂದ್ರೆ ಅವ್ರಿಗೆ ನ್ಯಾಯ ಸಿಕ್ಕುದಾದ್ರೆ, ಕಾನೂನಿನ ಚೌಕಟ್ಟಿನಲ್ಲಿ ನ್ಯಾಯ ಸಿಕ್ಕುದಾದ್ರೆ ನಾನು ಮಧ್ಯೆ ಬರಬಾರ್ದು ಅಂತ ಒಂದು ಧೋರಣೆ. ಹೀಗಾಗಿ ವಾಸುದೇವ ರೆಡ್ಡಿ ಅವರು ಒಂದು ದೊಡ್ಡ ಸ್ಥಾನ ಸಂಪಾದಿಸಿದ್ರು. ಟುಡೇ ದೇರ್ ಇಸ್ ನೋಬಡಿ ಹೂ ಕ್ಯಾನ್ ಈಕ್ವಲ್ ಹಿಮ್ ಇನ್ ಹಿಸ್ ಅಪ್ರೋಚ್, ಕಮಿಟ್ಮೆಂಟ್ ಅಂಡ್ ಇಂಟೆಲಿಜೆನ್ಸ್. ವಾಸುದೇವ ರೆಡ್ಡಿ ಅವರಿಗೆ ನಾನು ಪದೇ ಪದೇ ಆ ಶಬ್ದಕ್ಕೆ ಬರ್ಬೇಕಾಗತ್ತೆ. ಹಿ ವಾಸ್ ಅನ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಂಡ್ ನಾಟ್ ಎ ವ್ಯಕ್ತಿ. ಈ ಇದಾಯ್ತು. ನೆಕ್ಸ್ಟ್, ಹಿ ಯೂಸ್ ಟು ಎನ್ಕರೇಜ್ ಯಂಗ್ಸ್ಟರ್ಸ್. ವಿ ಹ್ಯಾವ್ ಒನ್ ಆಫ್ ಅವರ್ senior advocates today in the bar. His name is Mr. B.V. Shankar. He received abundant help from Mr. Vasudev Reddy barrister, and in his younger days, perhaps even as a student, he received considerable support from Mr. Vasudev Reddy and Mr. Shantraj, and Mr. Shankar is today a flourishing advocate, and I think he agrees with me that Mr. Vasudev Reddy made him what he is today. Now Shankar is number one, Mr. Shankar Nandrao is the other. I cannot go on listing the names of the advocates. All that I can say is Mr. Vasudev Reddy has contributed to the development of the bar, to the development of law, evolution of theories, and he was the first man to introduce the world. The action taken by the state is not informed of the protection in Part 3 of the Constitution. Look at the way in which he used to tell the court. The action taken by the government is not informed of the protection afforded in Article 14, 19, and 21. This was the way in which he was making submissions to the court and earned the confidence of the court in a greater measure. The government advocates come and go. Government advocates are not permanent features to the High Court, and they are there today, and tomorrow they would either be elevated or they would go back to their original work. But Mr. Vasudev Reddy flourished as a government advocate, and he took the profession, standard of the profession to the greatest height possible in his regime as a government advocate. I think we can go on narrating so many things about him. Well, many of you may be aware, may not be aware. ನ್ಯಾಯ ಮಿತ್ರ ಅಂತ ಒಂದು ಬ್ಯಾಂಕ್ ಇದೆ. ಆ ಬ್ಯಾಂಕಿನ ಫೌಂಡರ್ ಡೈರೆಕ್ಟರ್ ಅವರು ಅಂಡ್ ಫೌಂಡರ್ ಪ್ರೆಸಿಡೆಂಟು ಅವರು ಸ್ವತಃ ದುಡ್ಡು ಹಾಕಿ ಆ ನ್ಯಾಯ ಮಿತ್ರದ ಒಂದು ಸಹಕಾರದ ಬ್ಯಾಂಕ್ ಅಂತ ಒಂದು ಸಾಧನೆ ಮಾಡಿದ್ರು. ಯಾತಿಕಪ್ಪ ಇದು ನೀವ್ಯಾತಿಗೂ ಈ ತಲೆ ಬಿಡಿಸ್ಕೊಡ್ತೀರ ಅಂತಂದ್ರೆ, ಅಡ್ವೊಕೇಟ್ಸ್ಗೆ ಯಾವ ಬ್ಯಾಂಕಲ್ಲೂ ಸಾಲ ಕೊಡಲ್ಲ, LIC ಸಾಲ ಕೊಡೋದಿಲ್ಲ. ನಮ್ಮ ಅಡ್ವೊಕೇಟ್ಸ್ ಉದ್ಧಾರ ಮಾಡ್ಬೇಕಾದ್ರೆ ಯಾವ್ದಾದ್ರು ಒಂದು ಸಂಸ್ಥೆ ಇರಬೇಕು. ಐ ಆಮ್ ಪ್ರಿಪೇರ್ಡ್ ಟು ಪುಟ್ ಮೈ ಮನಿ ಅಂಡ್ ಯು ಆಲ್ಸೋ ಪುಟ್ ಅಂತ ಹೇಳಿ ನಮ್ಗಳತ್ತೆಲ್ಲ ಶೇರ್ಸ್ ತರಿಸ್ಕೊಂಡ್ರು. ಅವಾಗ 5 ಲಕ್ಷ ರೂಪಾಯಿ ಶೇರ್ಸ್ ಕೊಡ್ಸೋದು ನಮಗೆಲ್ಲ. We are happy with that money, and because there is good return from that. It is Vasudev Reddy, barrister, who started our Nyaya Mitra Cooperative Bank. Many of us are not aware, and today this institution comes to the aid of advocates of all the grades and types. He did not make any distinction in regard to the qualification to receive the loan from the Nyaya Mitra Bank. He organized. There must be need. There must be justification. The money is given to them must be channelized in spending, and there is to be collateral. The banking interest is taken care of. The interest of the advocate is taken care of. Then the samstha earns money in that. This is how he visualized that there could be own bank of the advocates, and it could flourish, say, in the limited area of operation. Today, it is declaring dividends at a reasonably high percentage, and Nyaya Mitra owes its existence to them. There is another aspect which we must recall and cherish. It is this. Mr. Vasudev Reddy had sought for a premises in Kabban Park for opening a club for the advocates. It is not the club in the normal sense. It is not a club with bar license. It is not a club with swimming pool. It is not a club with screens and auditorium. It was a club for the educated, informed advocates. Educated, I'm using the word not by in terms of the qualification, but in terms of education as a lawyer. He wanted to earmark this club for a particular purpose, namely growth of knowledge. And he did not succeed. Government did not give him. Where he failed, Mr. Basuraj has succeeded. Mr. Basuraj has started Daksha Legal, and he has succeeded, and he has implemented Mr. Vasudev Reddy's thing. I think enough about it. Now, perhaps next thing that I can mention about Mr. Vasudev Reddy is that he promoted the interests of lady advocates. He was the first man to introduce that government advocates should have more number of lady advocates to represent the cause. He was the first man to say that ladies should be appointed judge. At that time when we all were in the bar, and there were 2 lady advocates of 3, Lalitamma, Ansuya and Zubaira Begum. These were the 3, and Vasudev Reddy could not do anything because they were overqualified in terms of age to be a judge. That's where he stopped. And afterwards, he has seen a number of them coming up. And I think Manjula Chellur also was one of the lady advocates who was sponsored by him, became district judge, then became the High Court judge, retired as Chief Justice also. Well, whatever may be, Mr. Vasudev Reddy has done so much for the bar, and we all cherish him. With this, I think we'll have to think Mr. Vasudev Reddy in the background of the constitutional law and the local bodies, this number of statutes that he has prepared. I have prepared a note and I have requested the Karnataka State Bar Council to make use of this note, so to say that this is a ode in the memory of Barrister Vasudev Reddy. I think I should start narrating what I have said in this note. I think the best thing is to start with a subject which is known to us but not too familiar. You remember, Keshwananda Bharati was the first decision to herald, I'm using the word herald, the basic features. I'm not saying that it is the first time that Supreme Court used this expression, basic feature, in any of its earlier judgments. Justice Khanna has acknowledged the fact that he drew inspiration from Justice Mudholkar when he decided Sajjan Singh. The term feature of the Constitution occurred there. Justice Khanna also goes on record to say that the terms, basic feature adopted or noticed by Mudholkar is the inspiration he drew from the decision of the Supreme Court of Pakistan when Chief Justice A.R. Cornelius used an expression similar to this. Cornelius said, in the guise of removing difficulties in the working of the Constitution, in the implementation of the Constitution, court has no power to remove fundamental feature of the Constitution. Kindly look at the phrasing of the words by Justice Cornelius. In an attempt to remove difficulties, don't take away the basic feature of the Constitution. A beautiful statement. This appeal to Justice Mudholkar. Justice Mudholkar used in Sajjan Singh, and Justice Khanna borrowed it from Justice Mudholkar, and he elaborated as a basic feature of the Constitution. The evolution is in the guise of removing difficulties, do not breach the features, basic aspect, fundamentals of the Constitution. That involved as basic features, now basic structure. So this basic, all of us say that this Falkewala's imagination, and he used it with the help of an apprentice sitting by his side when he argued this matter. This is for the purpose of encouraging the students and apprentices. The statement must have been made. The truth is, Cornelius used it in the Supreme Court of Pakistan. Justice Mudholkar improvised on it, and Justice Khanna improved it and put it in the form of the present situation. It has become a jargon, namely basic features of the Constitution. What do you call this in terms of the Constitution? What do you call this process of evolving and reaching this situation? It is called as transmigration of ideas in the field of constitutional law, and is referred to as comparative constitutional advocacy. We people are wonderful in using the expressions. The lawyers give them, say, ask them to explain an orange being given to Shankar. They would explain it in 10 paragraphs. That is the wonderful power of speech of the advocates and the gift of language of the advocates. And that's why this Justice Khanna used the word transmigration of ideas in the field of constitutional law is referred to as comparative constitutional advocacy when he propounded the fundamental rights or fundamental features of the Constitution or basic features of the Constitution. Now, we will have to see this jargon. Has it gained currency? Has it been improved, or has it been taken to new heights? None of them. What we often use, either in Article 226 or Article 32 question, is that whether it is appropriate or not, we say this action of the government smacks of the effect of destroying the basic features of the Constitution. Good or bad or ugly, we use this phrase jargon of breach of features, the basic features of the Constitution in every picture, and this has become a common. And to the point of laughter, to the point of tell you that the humor has limit, but this is not humor. This is humoring the provisions of the Constitution, and we have reached a situation where every now and then we use this phrase, and it's not appropriate. Well, then we have another situation which finds mention while speaking about Vasudev Reddy, the barrister. All of us are aware that A.N. Rai superseded 3 senior most judges in the year 1973, and there was an attempt to please the power that be, and one of the attempts made was to overturn the ruling in Keshavananda Bharati, reverse it and say this, the Article 368 can be used, not, and basic features should not come in the way. He constituted, the A. N. Ray constituted a 13-judge bench to find fault with the basic judgment in Keshavananda Bharati and to overrule the majority decision. This judgment, and then 13 judges sat. Palkewala was the sole arguing counsel, and he thundered down. And see, everybody was, all the 12 judges were convinced, except the 13th judge, namely Justice Ray, was not convinced. First day, arguments went from 10:30 to 4:30. The next day, immediately after lunch, when Mr. Ray, the Chief Justice, learned that the majority was not with him and all the 12 judges are against him, he simply stood up and said, without seeking the concurrence of the brother judges, the bench is dissolved. Well, the bench was dissolved, the problem was not resolved. And if, on a later side, that reference or review petition or whatever you call it, which was heard by 13 judges in 1973, still remains on the record as an undisposed of case in Supreme Court. Whether we can take pride in it or not, 73 plus 37 years in the previous century, 22 years in the present century, 55 years, we are still under the impression that the case is not decided. Problem is dissolved, problem is not resolved. The bench is dissolved, the issue remains. So is that a compliment to us? And we have, every now and then we say that such a thing happened, post this matter in the middle of the night, tomorrow morning we'll give the result. There are cases and cases where no action is taken. We have the West Bengal case, the post-election murders and violence. That was the most important thing to be decided at that time, and it is now not seen the light of the day. We have innumerable cases of this type where the action is wanting, the judicial attention is missing, and we pay attention to a case that is coming up tomorrow morning, but we forget the case that we had argued like a previous day. This is an unfortunate situation, and we have got to cope up with this. Greater quantitative increase in the number of judges will not result in qualitative increase in the value of the judgments. This is a serious issue, and we have got to consider it. More number of judges does not amount to more number of disposals. The quality of judgment is the supreme criteria, and it shall not be sacrificed for any reason. This is our desire. A dubious distinction has come to stay in regard to the pendency of the matters in Supreme Court, and I can only quote Justice Mr. Nariman, the senior advocate, God only must save our Supreme Court. I think with this, I say that I have finished my ode, or whatever I have to say in the memory of Mr. Barrister Vasudev Reddy. I think we should go to the subject assigned today, because it's nearing 6:30, and we'll have to speak at least after about 20-25 minutes on the subject of the local body. Well, we are the largest democracy in the world. We have given to ourselves the reins of ruling the country as a democratic institution. Can there be democratic institution at the apex level, namely the Delhi? And can there be want of this democratic process in the other echelons down to the grassroots level? That we have seen and witnessed the 72nd and 73rd Amendment to the Constitution, whereby these local bodies, panchayats, municipalities, corporations, Nagar Sabhas, all these things were created and were given effect to, and we have today those glorious institutions working and implementing the grassroots level democracy. We have other laws like country planning, country and town and country planning, Local Development Authorities Act, then this Karnataka Industries and Area Development Act. All these things are intended to enthuse the citizens of the Karnataka or the people of Karnataka to realize the value of the infrastructure we have and convert that infrastructure into, say, some sort of some concrete terms of progress for the good of the society. We'll have to do a lot in these matters. Then going back to the earliest narration, namely the democratic institution at the top level must percolate, and this democracy must be enjoyed at grassroots level is the motto of the Constitution, namely Part 9 and Part 9A of Constitution of India. Well, we'll have to see that law is made in terms of the provisions of the Constitution by exercising by referring to the entries which are the fields of legislation in list 2 and list 3. If we take stock of the situation and if we go on enlisting the statutes we have made, we feel that the statutes are there aplenty and its implementation is wanting. We have all the laws that govern these aspects. We have the budgetary provisions, yet certain issues have not resolved themselves, and amenities and facilities that should reach the people at villages have not yet reached. Is there concentration of the progressive steps only in urban areas? Is the question that haunts us. Yes, urban areas have been developed and overdeveloped. ಕನ್ನಡದಲ್ಲಿ ಹೇಳೋದಾದ್ರೆ ಈಗ ಬೆಂಗಳೂರಿಗೆ ಬಂದವನು ವಾಪಸ್ ಹೋಗಕ್ಕೆ ಇಷ್ಟಪಡೋದಿಲ್ಲ. ಕಾರಣ facilities are too many, opportunities are galore, and nobody can be unhappy in Bangalore. Nobody sleeps without morsel of food, without a shelter over his head. There are the people not there now sleeping on pavements. People are not there in eating from the gutters. No, people have become highly sophisticated. Even the people in our roads are well informed of the health issues, and they are there in their own right. And therefore, what I have said is the infrastructural facilities are spread over in Bangalore in nook and corner, but the same facilities are not there in the other parts of the state. That must reach them. The drinking water facilities, gas, cooking gas, then this motor vehicles, affordable roads, all these things are now seeing the light of the day. We have seen the development of the infrastructure, and we have also seen foreign countries coming and investing their money in the direction of creating industrial opportunities. Factories have come up. We have when we were all young, there were only two vehicles, namely Ambassador and Fiat. In course of time, the Standard Motors introduced the Herald Triumph and Herald vehicles, the 2-door and the 4-door. Today, we cannot keep count of the number of models of the cars, the luxury cars, the deluxe cars, and the costliest car to the cheapest car. Nano, the cheapest and costliest car we have. The manufacturers have zeroed down in Bangalore, and we have almost all factories, all modes of transportation is available there. The transport vehicle, non-transport vehicle, the tractors and trailers, the auto rickshaws, scooters, electric bikes, everything is available in Bangalore, only for the reason that infrastructure development has seen its glorious days in Bangalore. Well, we will have to taking it forward, we'll have to analyze the part 9 and part 9A of the Constitution of India. And this is where Mr. Vasudev Reddy will be remembered by all of us. He was one man who was always saying that if you want democracy to flourish, it must start from the bottom. It cannot well seen exercising itself at the top level. Do not concentrate on parliament and legislative assemblies, the Rajya Sabhas and the legislative councils. Please concentrate on local source. Self-rule has to come in from the lowest point. We have the panchayats, we have the Nagar Sabhas, we have the municipalities, we have corporations. This is all the local bodies where self-rule is imposed, practiced, and flourishing. Side by side, we have the town and country planning, which provides for development of Bangalore as a model area, model city. But for this town and country planning, but for urban development acts, we would not have seen the present cities and urban areas. We have, look at that. We have conceived of a road which takes a motorist from starting from Bangalore to reach Mysore in 90 minutes between two toll gates. 90 minutes is a lot of savings in terms of the number of hours, the usual number of hours we take to reach from Bangalore to Mysore. We have other facilities. We have airports in every other district level now. They take, for example, Dharwad. We have number of flights. Gulbarga, number of flights. So these facilities are getting improved by reason of these planning and these local bodies and our development activities. Well, they will have certain limitations in the matter of local bodies, namely the term is fixed. The term is fixed in such a fashion that it becomes inviolable. 243E and 243U are the two provisions which say the term of elected body shall commence from the date of first meeting and at the end of the 5th year thereof, and no longer. No longer is the emphasis. The Constitution bench in Tomar has held that election shall not be postponed beyond 5 years. Election shall be held well within time. And if the voters list is not ready, the demography is not ready, geographical units are not ready, then the classifications and the other units are not the inputs for holding an election on the basis of representation is not ready, does not matter. What was ready, what was available in your record for the previous term, on that basis you hold this. Paragraph 19 of Tomar's judgment. Tomar was a person who challenged this, saying that this shall not be done. In our case, one Mr. Nagaraj from Dharwad filed a writ petition, and it was converted into a public interest litigation. Justice Woka was the Honorable Chief Justice at that time. The matter was heard and direction was issued. They are the senior advocate appearing for the election commissioner, showed his angst and said this is unnecessarily delayed. It is due. The election was due in the end of November 1919. At least 20 it should have been held. The direction was issued. The election shall be held within a period of 6 months. The matter was taken to Supreme Court. Supreme Court affirmed it but said that no further extension, do it. High Court decision, the direction is not valued and respected. Decision of the Supreme Court, Article 136 is not valued and respected, and elections with BBMP are not held even now. And they want 6 more months time to hold the elections. 2019, the term was over. 2000 November and 2019. Yeah, 20 it had to be held. Though the Constitution says that it shall be held at the end of 5 years or no longer. The term is never should extend beyond the 5 years. We have 9th year of the elected body, and the elected body is not working. Administrative is working. Are we respecting the Constitution? And was there already soul will turn in his grave? And he would certainly be worried that the law of the land is not obeyed. This is one instance, and there are ever so many instances of this type where law is not, the Constitution provisions are not obeyed. We have got to do something about it. And the more we are worried, the more the deeper we are getting into trouble of this exercise of the election commissioner and the reluctance of the government to hold the elections. Well, this we have section 243D. What is this special feature in section 243, which is similar to 243T? Panchayat and municipalities. 243D refers to Panchayat and 243T refers to the municipalities. What is this 243D and 243T? Reservation. What is reservation? It is the other side of, or a looser term for emancipation. The two words do not sound very harmoniously in the sense, what is reservation, what is emancipation? Reservation is for representation. There has to be representation from all sections of the society. Hinde, namage tilsage, member of the representative MRA, member of the representative assembly. The British Rajaro ನಾಮನೆ ಊರಿನ ದೊಡ್ಡ ಸಾಹುಕಾರನ ಕರೆದ್ಬಿಟ್ಟು ಜರಿಪೇಟ ಮತ್ತು ಆ ಲಾಂಗ್ ಕೋಟು ಚಿನ್ನದ ವಾಚ್ನ ಕಟ್ಕೊಟ್ಟ ಮನುಷ್ಯನ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ಅಸೆಂಬ್ಲಿ ಅಂತ ಚೂಸ್ ಮಾಡೋದು. ಅವರು ದೇರ್ ಆಲ್ ಎಸ್ ಮೆನ್, ಏನ್ ಹೇಳ್ತೋ ಅದನ್ನ ಎಸ್ ಅಂತ ಹೇಳಿ ನಡ್ಸ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ರು. ಅದನ್ನ ತಪ್ಪಿಸಿ ನಾವು ಎಲ್ಲರಿಗೂ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಡಬೇಕು, ಎಲ್ಲರಿಗೂ ಸಹ ಒಂದು ಆಪರ್ಚುನಿಟಿ ಕೊಡಬೇಕು. ಡೆಮೋಕ್ರಸಿ cannot be confined to a section of the society. It has to permeate and percolate to all sections of the society. Everybody should have the voice, should have the say in the matter of governance. This was the criteria for the purpose of collective responsibility. Representation is related to reservation. Reservation is related to the population, the extent of population. If a particular section is enormous in its strength or in its number, and if there is no representation at all, it is anti-constitution. So therefore, situation came saying that each sections will have represented. More importantly, we have seen for hundreds of years, the oppressed class being neglected and continuously being neglected. The British, before in exercise with the powers under 1935 Act, brought about reservation, and that reservation used the word depressed class. I'm not happy with the word depressed class. It should not have been. Nobody is depressed. He has a right to be as a fellow citizen along with me and along with others. That reservation was given for the depressed class. They didn't want to use the word anything else. And only when Constitution came into force, Article 366 showed indulgence to say, who are these persons who are neglected? Who are these persons who have never been continuously kept out of representation? Who are these persons who have not been allowed to participate in the affairs of self-governance? They identified these classes, enumerated them, and didn't want to give any name to the class as a whole. They said scheduled class, scheduled caste, scheduled caste, scheduled tribe, one category. The other is backward classes. Both the provisions refer to a category of persons. They say that these persons have been kept out of power, out of participation, out of democratic setup, and for all times to come, this is not proper or appropriate, because the preamble says, we the people, we are the sovereign, the people are the sovereign, and we give ourselves the constitution which spells out democracy, which spells out republic nature, and which is secular, socialistic. So therefore, the resultant situation was there is in existence from 26/1/1950 a democratic republic operating in India. This democratic republic cannot be on paper. It has to work out itself in terms of reality. So therefore, they introduced due representation. Due qua this section which has a particular population. And with this reservation, that has to come. Look at the wisdom of 243D and 243E. They say that it has to be a rotation. Is it physical rotation? No. The rotation is actually based on the number of people there and who have not been given the opportunity at all. So the rotation is not a clockwise rotation or looking at the needle. It's 9 o'clock, X comes. It's 6 o'clock, Y comes. It's 3 o'clock, somebody comes. 12 o'clock, somebody else. No, that is not scientific rotation or political rotation or social rotation in terms of the preamble of the Constitution, or in terms of Article 243D and 243T. The rotation assumed a new meaning. Rotation to those who have been continuously ignored, who have never got a chance. With this situation, we have the due representation operating. This due representation, every time a category is provided reservation, there is the 100 and 200 requisitions are filed, and all that it does is to increase the bank balance of the advocates. Well, we'll go to the other aspect, namely this women. What is it that we have done to allow women to be represented in these democratic institutions? Law has to be made to say that every woman shall have the right to represent her sisters in the area they reside. That's again 243D and 243U, which says there shall be representation. Look at the glorious manner in which representation is given or accorded. 1/3 of the number of seats available should be earmarked for women. I think this is a very glorious step taken by the framers of the Constitution and the person who are responsible for the further amendment and working up to date. Women today represent 1/3 of the women today in the society represent us, me and you, in the democratic institutions. Is this not a glorious development in our history and in our constitutional growth? One has got to admit that by giving due representation to the women, by giving due representation to the scheduled castes and scheduled tribes, we have done ourselves great service in really implementing our preamble of the Constitution. The story does not stop there. Well, we have the various sections which can never be represented in these things. They come under the general category. The general category also has a due representation. You people, have ruled the country for long. Your world was law. and people used to fall at your feet and take your advice seriously and or adjust their affairs, manage their problems, or continue to live in a decent manner. A time has come for the others to listen to I recall the word of the British depressed. We have got to listen to the voice of the voiceless, the voice of the persons who had no role at all to play in the growth, in the evolution in the society. We have the due representation and we have got to do so many things. So Article 243 and 243 alone has seen amendment to a great extent. 243A to Z and then Z to ZG. The electoral process shall not be called in question as a special feature, which is equivalent with Article 329A and B. The electoral process has started and it stops. The only exception is in Gujarat, Union of India sought variance after the calendar of events was published, and the government of India, the party in power in Gujarat was different from party in Union of India was different. They settled score by meddling with the process of election midway. The Election Commissioner of Gujarat took up the matter to Supreme Court, and all that he said was only one word: 329A and B. The moment the electoral process started, nobody can meddle with it. And now the High Court of Gujarat has done this, and this is not permissible in law. Justice Venkatachalaya and Justice Mohan wrote the judgment. It's reported decision, Election Commissioner of Gujarat versus Union of India, 1995, Supplementary Volume 3, page 643. I quote paragraph 8. The opening sentence of paragraph 8 is this: there are no unreviewable discretions in the constitutional dispensation. If the Gujarat Election Commissioner has found fault, has programmed the election in a particular manner and it was defective, Article 226 would enable the aggrieved party to get it corrected, notwithstanding Article 329A and B. This was the first decision which heralded the new concept, saying that there are no unreviewable discretions in the constitutional dispensation. It's only Mr. Venkatachalaya, as he then was, the Honorable Chief Justice, who could say this, and he did say this. Most of us do not use this decision often. There are no unreviewable discretions in the constitutional dispensation. We say that certain writ petitions are not maintainable. Appearing for the respondent, we always say that writ petitions of 226 cannot be used. There are alternative remedies. Let him go in appeal. In a proceeding without the notice to the other side, without making him or her a party, if an order is passed affecting his or her rights, should we go in appeal and say waste time? Or from there is the Assistant Commission to the Deputy Commission to the KAT to High Court, single judge to the Division Bench to Article 136. No, they have put their foot down and said if principles of natural justice are not are violated and are not obeyed, then no appeal is necessary, and you can directly approach Article 226. That's on the basis that there are no unreviewable discretions in the constitutional dispensation. We are going to learn so much from this Election Commissioner Gujarat versus Union of India. Then we have say this 243E. What is 243E? Duration of the principality deals with the disqualification of the members of the local body. It deals with the panchayat's duration and the disqualification of the members of the local body. This is a unique feature, and I must at once say that there's a local law, it's a state subject, and there's a law is made in terms of entries in list 2, and those laws which are holding the field today covers enough for it, namely in the matter of the duration of the panchayat and also in the matter of disqualification of the members of the local body. Then the 243H empowers the panchayats to impose tax, raise funds, and deal with financial matters. If you give the power but not the funds, panchayats cannot do anything. If you give the power to municipality and impose duties on them, do not provide funds, do not allow them to generate money, what can they do? The most essential thing in our the governance is money, funds. The funds must be generated. There is no provision at all. That the family of Article 243 and sub-articles, they provide the best panacea in the matter of self-governance, democracy at grassroots level, and local bodies. We have then this wards and committees have to be prepared. How do we do it? On what basis? Wards are to be created. Then we'll have to committees have to be constituted, and the wards will be in the hands of these committees, and the committee will have to supervise the development. This can be done only in terms of the articles provided in Article 243 family. Then we have this BBMP. I mentioned to you that Bangalore Brihatnagar Mahalpalika has not held elections at all, and it is overdue, and something has to be done about it. Then we'll have to think of land use in terms of the Urban Development Act, KSBC Act, and other things. If the land is under Section 3 of the Karnataka Industrial Areas Development Act, is declared as a commercial land, it can never be undone. There is no provision in the statute which allows it to be revert back into the original form. Yet, government of Karnataka has been indulging in several instances. The recent thing was the recent situation was heard in Kotal number 2, Justice Araji and Justice Vishwajit Ray. About 460 acres of land were declared under Section 3(1) of the KSBC Act as commercial land, and it was earmarked for being given to this ABCD, the industry. There are 19 industries which have taken this land. About, each of them have got more than 50 acres of land to them, and it is given on lease basis. Though law does not provide for sale of the land continues to vest in the state of Karnataka, and it only to be given on lease on certain terms and conditions which provides for improvement of the industrial prospects of the state, were given on lease cum sale basis by making a rule without power or authority, and the documents are executed as lease cum sale basis. 10 years lease amount is taken, 4,46,000 rupees taken for 70 acres of land and given on 10 years lease. On the expiry of 10 years, some clerk in the KSBC office proposes 10 years lease is expired, will sell the sale deed. The sale deed is executed, no consideration, fresh consideration. In consideration of 4,46,000 we paid at the time of commencement of the lease, the land is given. 50 or 60 acres of land whose value is more than 100 acres per land is given away for a throwaway price, and a writ petition filed was dismissed on the ground that you are no local standard. This is our governance. This is our governance. I think this Urban Development Act, I think I must conclude by saying that in Vinayaka Cooperative Housing Building Society, the situation came where land was acquired for a particular purpose, and these civil communities and other areas were earmarked for residential purpose. Change of land use in the reported decision in AR, Vinayaka Cooperative Society, Housing Cooperative Society, Justice Nazir Ahmed, Honorable Justice Nazir Ahmed has held in paragraphs 42 and 43 that land use shall not be changed at any cost, and we have warned BDA and the local authorities, including KSBC, that land use shall not be changed. Yet it is done. It is done with vengeance. I think Mr. Vasudev Reddy would be pleased to know that his contribution to the growth of urban development law and the local bodies has seen the zenith of its progress, and we all remember Mr. Vasudev Reddy with gratitude and with a lot of respect, and we say that you were a champion of the local bodies, and you had done your bit, and we are trying to continue and emulate you in our humble way. Thank you.
ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಮತ್ತು ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ ಲಾ ಅಕಾಡೆಮಿ ಇವರ ವತಿಯಿಂದ ನಡೆಯುತ್ತಿರುವ ಬೆಳಕು ಉಪನ್ಯಾಸ ಮಾಲಿಕೆಯಲ್ಲಿ 3ನೇ ಕಾರ್ಯಕ್ರಮವನ್ನ ಅತ್ಯಂತ ಯಶಸ್ವಿಯಾಗಿ ನಡೆಸಿಕೊಟ್ಟಂತ ಶ್ರೀ SP ಶಂಕರ್ ಹಿರಿಯ ವಕೀಲರಿಗೆ ನಮ್ಮ ಎಲ್ಲ ವಕೀಲ ವೃಂದದ ಪರವಾಗಿ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸುತ್ತಿದ್ದೇನೆ. ಮತ್ತೆ ಒಂದು ದಿವಸ ಮುಂದಿನ 15/12/2022 ಮತ್ತೊಂದು ಆ ಬೆಳಕು ಕಾರ್ಯಕ್ರಮದ ಉಪನ್ಯಾಸ ಮಾಲಿಕೆಯಲ್ಲಿ ತಮ್ಮನ್ನು ಭೇಟಿಯಾಗಲಿದ್ದೇವೆ. ಅಲ್ಲಿವರೆಗೂ ಶುಭ ಸಂಜೆ. ಧನ್ಯವಾದಗಳು.